Everyone who's been wronged in business or who've been taken advantage of financially during probate or in a trust wants to go after the other parties to file a lawsuit against them. Attorney L. Reed Bloodworth, managing partner of Bloodworth Law PLLC in Orlando and Winter Haven, Florida, talks to clients about the time involved in a lawsuit and the stages in which a lawsuit proceeds. In the first stage of a lawsuit, the pleadings stage, Reed explains that he files a complaint stating what the other party did wrong and the harm that was caused by actions taken by the other party. Reed said that the second stage of a lawsuit is the discovery stage. The discovery stage is made up of paper discovery, evidence, and questions. Paper discovery means that Reed and the Bloodworth Law team attempt to gather all available information pertaining to a client case. It's evidence, and a lot of that evidence comes from a range of official sources, police records, contracts, paperwork signed by parties involved. It includes information provided in statements by witnesses and parties involved. Then Reed builds a case. The other thing that Reed does is serve written questions to the defendant. Those questions are known as interrogatories, and Reed has to get answers to those questions. Those are usually more basic questions such as who was involved and what happened. The other standard discovery tool is a deposition, which maybe you've seen on TV. But what happens in a deposition? The deposition involves the plaintiff or the defendant and their legal representation. Both parties may be represented, but you are not necessarily going to be seeing the defendant or the plaintiff. You are more likely to see the opposition's attorney in the deposition. The opposing counsel is allowed to ask you questions about what happened in the incident. Don't worry. Reed will prepare you in advance for the deposition so that you understand what will happen. Reed will also be at the deposition with you. You will be asked questions, and Reed will be there to raise objections should the opposing attorney become aggressive or ask questions that are not allowed. The reason the deposition is held is because both sides want to know exactly what's going to be said in a court of law should the case go to trial. Stories must be clear and should not change. If the other side attempts to say something different during a trial, Reed can then cross-examine them with their previous testimony. If you're facing trust litigation, probate litigation, business litigation, or employment law disputes, give Reed a call and find out how Bloodworth Law can help you, your family, or your business.